starting point to my presentation, I looked at the relationship that exists between human beings and animals, which is quite a complex one. And it has various contradictions. On the one hand, we see human beings expressing love and affection towards animals. And on the other hand, we have seen some highest levels of animal cruelty. And that is just the contradiction that you can find in the relationship between human beings and animals. And the justification for this, and I know all of you will understand, is because animals are regarded as property, or they're deemed as property for human benefit, and human beings are regarded as having dominion over animals, and as such, animals will not have any form of legal recognition as of right in their own rights. But if you look currently, the plight of animals, I can give an example of rhino poaching. It has been escalating in South Africa, and as a result of the plight of animals, there have been various dilemmas and issues that regard their status in society. And there have been a number of academics, and maybe some of you will have read a lot about different academics and philosophers who base their discussion on whether animals ought to be protected on various ethical and philosophical considerations. And this deals with how animals ought to be treated in society. And as early as the end of the second millennium, the effective protection of animals became one of the most prominent issues. And around or during this time, the legal protection of animals was essential in maintaining a healthy environment. And to enforce the protection of animals, criminal law played quite a critical and fundamental role, as it came in a form of criminalization of cruelty towards animals. However, even during this time, animals were still regarded as property, because this principle is deeply rooted in our law. But subsequently, as the law began to evolve, society started to move away from the perception that animals are mere property for human exploitation. And that shift began mostly with the enactment of the laws, but that was in the UK, where they started to recognize that animals ought to be protected in their own right. And I've been asked questions as to why I chose to do a comparison between South Africa and India and not any other country. And the first is that India is one of the superpowers when it comes to their constitution. And even the manner in which the constitution of India was then adopted, moving from colonialism, is quite similar to South Africa. And there have been suggestions that most of the scholars, and I'm sure most of you do that, when people try to do comparison studies, they usually look at countries like Canada, they look at the UK, and they look at the United States. But there have been suggestions that sometimes it's better to have comparison studies which do not focus on English or American jurisprudence and focus on other countries, and which is why I then chose India. And India is also one of the countries where the protection of animals in terms of their constitution is quite progressive, because the Supreme Court, which is the equivalent of our constitutional court, has held that animals deserve protection in terms of constitutional provisions. So that was the justification why I chose the comparison of South Africa with India. There were a number of countries that I had considered. For instance, Germany, they had included a clause which protects animals, the right to life. So the right to life, they added the words "and ditiere," which means "and animals." So it means the right to life was also protected to animals. Countries like Brazil as well, they have a progressive constitution when it comes to the protection of animals. But then I then chose to compare India. Then the starting point will be on the philosophical and various religious theories for the protection of animals. And some people might ask, why are you discussing those philosophical? Because we came here to listen to constitutional protection. But the reliance on this ethical philosophy is relevant in this study, as constitutional law cannot logically be separated from moral philosophy. There is a correlation between constitutional law and ethical philosophy, which is why there is a need to discuss the various philosophical theories upon which the constitutional principles that protect or ought to protect animals are based. And this will set a backdrop for modern protection of animals, which will be based on constitutional principles. Now, the main arguments that have been advanced towards the protection or otherwise of animals, there are two main school of thoughts or views, and I've taken them and grouped them into anthropocentric arguments and ecocentric arguments. With anthropocentric arguments, these are the arguments where you look at animals are protected based on how they benefit human beings, or the interests of human beings are always taken as being above everything else. And the starting point has been the religious worldview, and religions such as Christianity, for instance, are the ones who began to indicate whether or not animals ought to be protected. And when people come and say animals should not be protected, and these are arguments against animal protection based on anthropocentrism, they say it's because God gave dominion over animals. So human beings have dominion over animals. And yes, if you read the book of Genesis, yes, it does state that human beings have dominion over animals. But I found some weaknesses in this religious worldview to say, if you're saying animals don't have rights because human beings have dominion, the Bible, the same Bible that people are relying on, also states that human beings have no superiority over animals. And if you read a book like Proverbs, for instance, it says, a righteous man regardeth the life of his beast, but the tender mercies of the wicked are cruel. So it means if you are relying on the Bible to say animals do not have rights, and you are being cruel to animals, it means you're also going against the Bible. So that, to me, I found that those are where the weaknesses of the religious worldview. We have some theories like the theory of autonomy as propounded by Kant, and he speaks of autonomy as the basis for protecting animals or denying animals their rights. And this is actually an extension of the religious theory, and it looks at what animals cannot do as opposed to what human beings can do. But those arguments as well have been found by various scholars to be counterproductive, because if you're saying maybe you cannot protect an animal because it cannot speak, it means people that are deaf or people that are mute cannot be protected, or children who cannot perform certain things cannot be protected, and that is not so. We then have the next theory, which is based on consciousness, and some are saying that animals are not conscious, and scholars such as Descartes, Harrison, and Carruthers put these moral theories and say, well, because animals lack consciousness, they cannot be protected because they lack any interest of well-being. So because they don't have a well-being, they cannot be protected. But also, this one has been found also to be counterproductive, because there are like some people from the marginal cases, and there are some people who cannot do certain things. And the way recent scholars who found that there's no indication scientifically which proves that human beings have a soul. So if you're saying maybe because human beings have a soul and animals don't have, there was no scientific proof to show that human beings indeed have a soul. And the next one is the contractualist theories. And these theories have been advanced to say animals cannot enjoy any rights. But to me, I'm saying applying this theory can actually lead to animals having rights. What the contractualist theory says is that there is a veil of ignorance which needs to be put in front of everyone when you want to associate whether animals should have rights, and that is based on the theory of justice. So the concept of justice to them is the rules that govern individual beings are selected behind a veil of ignorance. So you as a human being, you don't know whether you will be a human being or an animal, or you will be a tree, you don't know, but then you have to choose whether you will choose things that will protect animals or not. And those theories find that people will choose theories that will not protect animals. I beg to differ with these theories, because if I don't know if I'm going to be an animal or not, I might want to protect myself and say, you know what, let me also protect animals, because if I don't protect animals and I end up being an animal, then it will be a problem for me because I will not have any legal protection. So applying this theory, even though it was used for anthropocentric arguments, I think it is actually contrary to that. So though the anthropocentric arguments suggest that animals have no direct moral standing, there are certain acts that may also not be done. Like if you torture an animal for the fun of it, people say it's wrong. But the question is, why is it wrong? Because if animals don't have any moral standing in society, it means you can do as you please. But people still say, no, those acts are wrong. But the basis for this is not because animals have any suffering that they consider, but because of how this affects human beings. And these anthropocentric arguments have been reflected in a number of South African judgments dealing with animals. While it was not animal rights per se, because animals are regarded as not having rights because of their status in society. But then we have the ecocentric arguments, which ought to provide for some protection of animals, and some require equal consideration of interest to liberate animals. So animals can have equal interests, so their interests will be considered equally with those of human beings. And since all human beings are regarded as being equal, notwithstanding their incapacities, so it means such consideration should be extended to animals. And we also have inherent value as the basis for protecting animals, which also looks at saying animals possess the same equal rights as human beings, but they don't regard those rights to be absolute, so those rights can be limited. And that can be justifiable in terms of the Constitution, because we know we have Section 36 of the Constitution, which the rights may be limited, certain rights can be limited. So some scholars have argued that if you then don't want to give animals rights just because they cannot do certain things, then that amounts to speciesism. So speciesism is actually some form of discrimination based on species. So if you're discriminating on animals because of their species, so that is deemed to be speciesism. Then we have ecocentric arguments also when you continue, which looks at the religious worldview. Like we spoke about religious worldview on anthropocentric arguments, but we also have it on ecocentric arguments. And for this, we have religions such as Hinduism and Buddhism, where nature is highly sacred and humans are not more significant than any other living thing. And for Hindus, they believe that human beings and animals possess the same souls. So it means this also rejects the theories that says animals should not be protected because they don't have the soul. And Buddhism as well believes in being compassionate towards all living beings, even though when you look at Buddhism, it does have two different views. The first one is that if you kill a sentient being, because when you be rebirth, you can be reborn to become a sentient being as well. So maybe let's say you were a human being, you can be born as an animal. So if you kill another sentient being, that is actually proscribed and you are not allowed to do that. However, I then thought, yes, we have ecocentric arguments, we have anthropocentric arguments. Why don't we protect animals based on both? Does it necessarily have to be one of them, or can we have both of them? And what I did is I have a conventional phrase. I haven't seen anyone writing that, so this phrase is actually mine, but it's just a combination of ecocentric and anthropocentric arguments. So I termed them eco-anthropocentric arguments. So those were the arguments which when I was looking at, they tend to look at both the ecocentric and the anthropocentric, and we are actually protecting animals for both their interest and also for how they benefit human beings. And different philosophical theories for protecting animals that I've discussed, they advance certain things or arguments as to why animals ought or ought not to be protected, but they give very little guidance to lawmakers on how these theories can be implemented into policy or into law. So, which is why we then look at some policies. For instance, if we look at practical philosophy, it's one of the least explored options to animal ethics. And this theory, if you look at it, it may provide a distinctive approach to animal ethics, even though it was not intended as a guide to animal ethics. the reason why I believe practical philosophy can be used is because it is based on context as opposed to theory. And this places it in a position where it will provide robust understanding of how human actions affect animals, as well as how animals affect human beings. So for it to be applied, it's also timeless, and it is easily adaptable. It's sort of like our customary law in South Africa, which can be adopted as the situation in the society is changing. So I then looked at the strengths and shortcomings of the protection regime in South Africa and India. Before I went to the constitution itself, there is a number of legislative enactments, both in South Africa and India, that ought to protect animals. And I think the basis for this is, if you look at our constitution, or any constitution for that matter, they are phrased in a very abstract manner. They just tell you have this right without actually qualifying that right and explaining what needs to happen to protect that right. So, for instance, everyone has a right to life. What does life mean? What does it entail? And who is everyone? The Constitution does not do that, which is why we then have legislation which will then come and give effect to those constitutional provisions and explain exactly what it means. For instance, the right to the environment, which is the only right which might protect animals in South Africa, arguably, even though it does not specifically state that, yes, animals are protected just as the environment. It is qualified in different legislative enactments. And discussions around the protection of animals should then start with the legal status of animals. Do we think animals are correctly regarded as property in South Africa, or any law for that matter? Because the law only grants duties or legal rights to only legal persons. But if we are saying animals cannot have rights, but at the same breath we're saying that a juristic person, which is an abstract person, it's not even like alive, cannot bleed, but it has rights, I think that there is some gap there, because we cannot just protect a juristic person which is not even alive and not recognize that animals also require some protection. And the extent to which South African law protects the animal of welfare can be assessed by looking at a range of those enacted legislation. So for South Africa, we have national legislation, we have provincial ordinances, and we also have some bylaws which are relevant in the protection of animals. But looking at the judicial view on the protection of animals in South Africa, it has the anthropocentric viewpoint. If you read cases such as R versus Moato and S versus Edmonds, the courts there found that legislation was not aimed at conferring legal rights to animals, but the only thing is it was to protect animals, but rather based on how the action of human beings may affect other human beings. For instance, if maybe I see someone torturing a cat, and because I have finer feelings and sensibilities, I might feel like offended by that. So the law is actually protecting me, an animal lover, and not an animal itself. And in India, what we have seen is the judicial view there has been ecocentric, and they've accepted that ecocentric protection of animals is the way to go. And there have been a number of cases such as T.N. Godavarman versus Union of India and others, cases such as Center for Environmental Law, Worldwide Fund of India versus Union of India and others. Those courts favored the ecocentric view to say the protection of animals has nothing to do with how they affect human beings. They have to be protected because of their own inherent worth. And another thing which I think even South Africa should look at, there was a case of Animal Welfare Board of India versus A. Nagaraja. That was the Supreme Court case. And the court there, this is what they stated. We may at the outset indicate, unfortunately, there is no international agreement that ensures that welfare and protection of animals. United States all these years safeguarded only the rights of human beings, not the rights of other species like animals, ignoring the fact that many of them, including bulls, are sacrificing their lives to alleviate human suffering, combating diseases, and as food for human consumption. International community should hang their head in shame for not recognizing their rights all these ages. A species which served the humanity from the time of Adam and Eve Of course, there has been a slow but observable shift from anthropocentric approach to a more nature's right-centric approach in international environmental law. So I argue that if the court here was saying that the international environment community should hang their head in shame for not recognizing the rights of animals, well, maybe the same thing should happen to South Africa. We have to hang our head in shame because we have not recognized the rights of animals. So now, when I come to the actual comparison of the constitutional protection of South Africa and India, there are various provisions that we can rely on. And first, I have to state that the recognition of animal rights within a constitutional framework only began recently, where some countries then began to include within their constitution the right of animals and the right to the environment. And constitutional law plays a new role now in the protection of animals because, like we know, in South Africa, Section 2 provides that the Constitution is the highest law of the land, and because the Constitution is supreme, it means if you protect animals within a constitutional framework, you will be offering them protection with the best or the most important law that can protect them. And South Africa is regarded as having elevated the environmental protection by including environmental rights. But when you look at Section 24, it does not expressly protect animals. The only section which is relevant is only Section 24. It says everyone has a right to an environment. And the only inference that we can take is because animals are part of the environment, then it means they are then protected. And there is also a problem which I found with even the provisions of Section 24, because this constitutional protection reflects also the anthropocentric view, because animals have to be protected for the benefit of present and future generations through reasonable and legislative and other means that promote, including those that promote conservation. So what we are looking at here is we are protecting animals still for how they affect the human beings. So if it is not for the benefit of the present and future generations, then we'll not even protect animals at all. And the protection of animals within the ambit of the South African Constitution was stated by the Supreme Court of Appeal in the case of State versus Limtongai. And in this case, the court stated that the constitutional values dictate a more caring attitude towards fellow humans, animals, and the environment. And this was the shift from South African judicial view that sometimes animals ought to be protected. And even though they are not per se ecocentric, but they do recognize that animals have some inherent worth which ought to be protected. And this was further elevated, the constitutional protection of animals, by the Constitutional Court in the case of National Council for Society for the Prevention of Cruelty to Animals versus Minister of Justice and Constitutional Development. And in this case, the court found that the rationale behind protecting animals has shifted from merely safeguarding the moral status of humans to placing intrinsic value on animals and individuals. So these cases are a shift from the initial anthropocentric views to now say, yes, animals do have some inherent worth. But we must understand that it is not sufficient to try and attempt to adopt measures that give effect to animal rights in isolation. And just looking at Section 24, for instance, because we know the rights in the Bill of Rights are interrelated and mutually supporting. This means that when we're dealing with the rights in Section 24, we may have to look in other sections that might have to protect animals. And another thing is there have been arguments that Section 24 only protects those animals that are in the wild. So what about those domesticated animals if they are not covered? Remember, Section 24 does not actually provide any clarification as to whether it protects animals per se or not, or just the environment in general. So this will mean that maybe animals can be protected in terms of Section 25, because if I've domesticated an animal, it becomes my own property in terms of property law. And if you deprive me of that property, maybe I can say that's a violation of Section 25 if that deprivation was arbitrary. But relying on this section is problematic because we are now reinforcing the status of animal as property. Then we have Section 38 of the Constitution, which provides for various people that may have local standing to enforce the rights in the Bill of Rights. For instance, if I feel like an animal is being abused, I might have standing in terms of Section 38 to say, well, there is a violation of the right to the environment. That is my right to the environment, which is protected, and I want to enforce that right. But the extent to which you can rely on this, there have been challenges where people have been using what is termed slap suits, where when you're trying to sue people for their violation, and they just come with those slap suits just to stop you from proceeding. We then have Section 9 of the Constitution, and with Section 9, I want you to look back at what my discussions on what other scholars have been saying, to say if you don't give animal rights just because they belong to a different species, that amounts to speciesism. So for that, we look at Section 9 of the Constitution, which protects animals. And the equivalent of Section 9 in India is Section 14 and 15. So our Section 9 is actually like broken down into two within the Indian Constitution. So Section 14 and 15, so the first part of our Section 9 is dealt with in Section 14 in India, and all these clauses protect the rights not to be discriminated, or equal protection of the law. And there are various grounds which have been stated as to you cannot discriminate on anyone based on various grounds. But we must remember that those grounds are not exhaustive. So maybe even discriminating on someone based on species is one of the grounds of discrimination. Now, there is an important question which can then be asked. Does the right to life protected under Section 11 of the Constitution has any implications for animals? Section 11 protects the right to life of everyone. So it says everyone has a right to life. Does everyone include animals or not? And remember, if you were to protect animals by giving them any other right, I argue that it will be redundant to give them any right if you cannot give them the right to life. Because if you give me a right to vote, for instance, but not a right to life, someone can just kill me and I will not be able to vote. So it means the right to life is the most important right that needs to be given to every living being. And there are scholars that say a being have a right to life just for the mere fact that that being is alive. And the guidance on how the right to life should be interpreted, I know we all know this. It has been stated by the Constitutional Court in the case of State versus Makwanyane. And this is what I like about what the court said, because the court found that it is only when there is willingness to protect the worst and the weakest among us that all of us can be secure that our own rights will be protected. So it means if we cannot protect animals which are vulnerable and which are being killed at an alarming rate, and they're weak, they cannot protect themselves, then we cannot be secure that even our own rights will be protected. So for us to be secure that our rights can be protected is when there is willingness to protect even the rights of animals. And if you look at, well, in the protection in India, we have now Article 21 of the Indian Constitution. And this article has been subject of contention because the Supreme Court of India has shown willingness to apply. Actually, it began from the High Court. The Kerala High Court was the first actually to recognize that animals ought to be protected in terms of Article 21. And Article 21 is the equivalent of our Section 11, which protects the right to life. So the Article 21 in India protects the right to life, and the court have extended this to include the life of animals. And if you look at the wording of Article 21 in India, that right has internal limitations. But if we look at Section 11 in South Africa, that right is a non-derogable right, because if you look at the table of rights, it's fully protected. So you cannot limit it, which is why even in State versus Makwanyane, the court found that, well, the death penalty was actually unconstitutional. So because you cannot limit that right in South Africa, you were supposed to even protect animals. But the courts in India, where the right is even limited, it has internal limitation. They have extended this to say, well, even animals ought to be protected within a constitutional framework. And the right to an environment is regarded as a fundamental right also in India. And just like with the right to equality is divided as opposed to the one that we have in South Africa. Our Section 24 is just in one section and have different subsections. But if you look in India, we have Article 48 and Article 51A. So those articles, the other one places an obligation on the state to protect the environment and animals. So it does mention even the life of animals, and it protects animals within the constitutional framework. So unlike in South Africa, where it's just the right to the environment, when you look at India, at least they do mention animals. And the one which requires people to protect animals as well, like a positive obligation on human beings, it is also stated in India as well. And the right to approach the courts, ours is section 38. In India, we have Article 32, which guarantees the right to approach the Supreme Court to enforce any rights in Part 3 of the Indian Constitution. And this section empowers the Supreme Court, which is the apex court in India, to listen to matters that relate to the violation of any rights. And the courts have found there that because the section itself does not specify who should approach the courts, anyone who feels like they will have legal standing in court can approach the court to enforce any legal rights, especially those that relate to animals. And so if you look at these sections, you will see that in India, they have sections which specifically state animals, but even though their sections have been limited, what they do is the courts use a liberal interpretation of the Constitution, and that approach is equivalent to what we have in South Africa of transformative constitutionalism, which for some reason it has not yet been used when it comes to animals. It has been used in various rights, like the right to housing and socio-economic rights. But in India, the courts have been willing to use these cases to say, you know what, even though sometimes the provisions may not be clear as to protecting animals, we can go and say, yes, when we interpret this, it has to include animals as well. And those are just like some minor differences between the protection in South Africa and India. And there has been willingness in India to protect animals and to even state that animals have rights. But in South Africa, most of the cases that you find always say that animals do not have rights, they're regarded as properties, even though the shift is now just to say, yes, they might be protected based on their intrinsic worth, but the focus is also based on how they affect human beings. And I think I will stop here and I will take some questions. Thank you.